Debt collection cases make up an alarming portion of the cases filed in Michigan's district courts, second only to traffic cases. According to a report by the Justice for All Commission, in 2019, creditors filed over 200,000 cases in Michigan. This report also revealed that just 10 plaintiffs account for almost 3/4 of all filings. And third-party debt collectors have expanded their presence in Michigan courts, in recent years showing a 40% increase over the past decade. While these cases are filed throughout the state, they disproportionately impact low and moderate income individuals, who are almost always unrepresented by legal counsel. On the other hand, creditors are usually represented by a lawyer. Regardless of income, Black communities are hit the hardest by debt collection cases. According to the Urban Institute, people living in majority Black communities in Michigan are twice as likely to have a debt in collection than someone living in a majority white community. So, in 2021, the Michigan Justice for All Commission convened a debt collection work group to provide insight into these alarming statistics and make recommendations for addressing them. Today on Legally Speaking, we will talk with two of the work group's members who will discuss the findings in the report and ideas for improving the debt collection process in Michigan. We'll be right back. Today on Legally Speaking, we're talking with two experts on consumer protection and financial exploitation. They're both members of the Justice for All Commission's work group on debt collection, and they're going to talk to us about the findings of that work group and their recommendations. Thanks so much for being here today.
Welcome.
First, I'd like to introduce Matt Andres as our first guest. He is a clinical law professor at the University of Michigan Law School, runs a veterans law clinic, and he's written reports and articles about debt collection litigation. Before that, Matt was at University of Illinois Law School, where he ran a elder abuse financial exploitation clinic, the first of its kind, as I understand.
That's right.
And did some work on model rules around financial exploitation. And long before that, Matt and I worked together at Cooley Law School's Family Law Assistance Project, where Matt was a fearless litigator on behalf of domestic violence survivors.
That's right. Well, thank you very much, Ashley, for having me, and it's great to be back with you again, finally, reunited.
It's good to see you. And Lorray Brown is the Executive Director of Michigan Statewide Advocacy Services that helps people living with low incomes, immigrant communities, and seniors. And Lorray is the Executive Director of that program that runs a number of sub-programs, including Michigan Poverty Law Program, the Foreclosure Prevention Project, Immigrant Rights Center, Elder Justice Initiatives, and the Michigan Legal Help Program. Lorray has been the managing attorney and statewide consumer specialist for the Michigan Poverty Law Program since 2001, which feels like just yesterday. I don't know how that happened. And she's trained hundreds, probably thousands of lawyers on issues about consumer law, predatory lending, foreclosure, and mortgage servicing. She's also been a consumer law fellow at the National Consumer Law Center and has been recognized for her amazing work in consumer protection by both the National Consumer Law Center and the Michigan State Bar Foundation's Access to Justice Award. So great to have you here.
Oh, thank you. Thanks for having me.
It's amazing. We have this really great wealth of knowledge about consumer protection and financial exploitation. So let's talk about the work that you all did with the Justice for All Commission. Lorray, maybe you can start by talking about the Justice for All Commission itself and kind of what that organization is.
Sure. So in 2021, the Justice for All Commission sort of formed and created by Michigan State Bar and the Michigan Supreme Court to really look at how Michigan's residents have access to the state civil justice system, to see how they're navigating the system, because the goal is to try to have 100% accessibility of Michigan residents to the court system, and to see if we can identify barriers to the court system and try to fix that and resolve that. In doing so, the Access for All Commission also looked at different subject matter areas and decided, let's see what's going on in each area. One of them is debt collection, so they created the debt collection work group.
And so you and Matt were both on that that
Yes.
work group, and who are the other members of that work group?
Yeah, and members of the debt collection work group included district court judges, because they're the ones that are seeing these debt collection cases on a daily basis. Consumer advocates, advocates on behalf of consumers who are dealing with debt collection. Also the creditors, so they're basically on both sides. So we had stakeholders on both sides to have much more of a comprehensive evaluation of the problem and identify the problem. We also had researchers, because one of the things we wanted to do is to do a deep dive into debt collection in Michigan. So we had Pew Trust and January Advisors who really did a lot of the research into the courts and looking at these cases, and that's where we get a lot of our data that we came out with. And so we were able to also look at national trends, what's going on in other states around debt collection, and how they're navigating, how their debt consumers are navigating the debt collection process in the courts. And so as a result of that, we looked at it, came up with some ideas and hopefully solutions and recommendations.
Great. So Matt, can you talk about that debt collection process? Like, what does it actually look like?
Sure. Yeah, a debt collection case is a general civil case, much like other civil matters, which are cases brought by one person against another person, so something that is not criminal. Let's say I go to Beaumont Hospital and have a procedure that I cannot necessarily afford, and get a bill for $4,000 that I can't pay. Beaumont Hospital will call me for a while trying to get me to pay, and eventually they will give up. They will have two choices at that point. They could, I guess they have the choice of not collecting the debt, but if they want to collect the debt, they can take me to court at that point, or they could sell the debt to a third-party debt buyer who would then try to call me and get me to pay. But ultimately, they would have to take me to court if they wanted to compel me to pay the debt. Okay. That is the one way. Going to court is the one way that they can compel a person to pay their debt.
Okay.
And so the court process starts with the filing of a complaint that tells what allegedly I did wrong to violate the law and how much money they are looking for in the debt collection case. And once that complaint is filed, then it is the responsibility of the plaintiff, who is either the creditor or the debt buyer, to serve that complaint on the defendant.
What does that mean? You say serve somebody with a complaint?
Right. So basically it's providing them the complaint, either in person or by mail. Certified mail is allowed, or in-person delivery. Often it will be accomplished through a process server. And if that is served on me, then I have a choice at that point whether to file an answer to that complaint. That's a document that is responding to the allegations in the complaint. And if I file an answer, I get to participate in the case. And there are basically four options when you participate. The first is you could go to court and acknowledge that you owe the debt and work out some kind of plan to pay it off over
So some
time.
sort of settlement of the debt.
Yeah, a settlement of the case.
Okay.
I may go to court and the creditor may decide that they don't have enough to prove that case, and so they might dismiss the case at that point. Or we could go to a trial, and ultimately the court may find that I am responsible for the debt, or may find that I am not responsible for the debt. So those four options exist if I participate.
What happens if you don't participate?
Well, that's the problem. Most people don't participate. So if you don't participate, then a default judgment is entered by the court. And that is basically a judgment saying you are responsible for the debt, but the court never hears the merits of the case and never actually determines whether you actually owe the debt.
But there's a judgment that says that I do owe the debt.
Yes, and so the effect is that you have to pay the debt no matter what, but you haven't done anything in any way to defend yourself or participate. And unfortunately, that happens in 68% of the cases in Michigan.
That people just don't participate in
People
the
don't
case.
participate, and it ends in a default judgment.
Okay.
And so the vast majority of these cases are ending in default judgments. And once there's a judgment, then the creditor has all of the tools available to them to compel you to pay that judgment. And so they can garnish your wages, they can seize your property, they can take your bank accounts or your tax returns.
Your tax returns, seems the one that people come to us the most about is,
yes.
Wait a minute, I thought I was getting this tax return and now I don't.
Yeah, people
have it.
plan for that money and then it doesn't show up and they wonder why, and they realize maybe for the first time that they've got a debt case out there, a debt judgment against them.
Got it. Well, it sounds like there's a lot of problems with the process. Maybe we could break it down and kind of talk about each of those pieces. So, Lorray, you want to start with kind of what's the first place with there's issues that arise?
Yeah, well, as Matt mentioned, once a collection pursued, right, then the plaintiff, debt buyer, will then file a complaint. And so that's the initiation, so the complaint is filed. But the problem there with the complaint stage is that oftentimes the complaint doesn't provide a sufficient evidence in there to actually prove that the person who's suing on the debt, one is suing on a valid debt, or is the actual person to be collecting on the debt. And so, for example, is suing on a valid debt. It could be a debt that is time barred. Time barred mean that the time period to collect on the debt has expired. So they might be suing on a debt that really you cannot sue anymore on. Or if the complaint is lacking sufficient evidence to show that the person has the right to collect on that debt, right? Meaning the person actually owns that debt to collect on it. And one of the reasons why these problems pop up is because of the industry, the debt buying industry. So the debt buying industry, Matt mentioned earlier about selling the debt, the creditor selling the debt. So the debt buying industry is, where often the creditor who decides to sells the debt. So often the creditor doesn't necessarily do it. The original creditor, you take it out to the original creditor. They then either retain a debt collector to collect on the debt on their behalf, but oftentimes they want to monetize the debt right away, so they quickly sell it to the debt buyer. And the debt buyer is, the industry, the model basically is they buy these debts in volumes, in huge volumes, in which, it's packaged together, so it's like lots of other people's debts, individual debts that they purchased for pennies on the dollar, so it's really quick. And so they will hold on to that, get this, and what happens during that time is that they don't know which debt they're buying, so it could be a time bar debt. They also, all of the necessary paperwork that needs to go along with these individual debts are not there because it's a bulk purchase. And so as a result of that, they don't have all the necessary information as well. And sometimes also it's being sold several different times. So usually the person then who's filing that complaint is this debt buyer is so far removed from the original creditor and is pulling from their bulk purchase a debt that might be time barred.
Or they might have paid it, right? Like somebody could have continued to pay on their debt that
exactly. And that's one of the reasons why it's really important to know, do you have the right to collect? Are you the owner of this debt? Because the debt buyer could sue you and you paid on it, and then another debt buyer gets it and says, no, I'm the real owner of that debt, so you owe me. And so it's really important to find out who the true owner is, and it's always necessary to have that paperwork attached to the complaint.
Okay, so if somebody sues, then if that's missing, then that's a problem with that case.
Yes.
Right?
Unfortunately, though, in Michigan law doesn't require that. So on the Michigan and the current rules, all that is required in a debt collection is that you just show the name of the creditor, the account number on the debt, and the amount. It doesn't ask for a breakdown of all of the costs and the fees that's attributed to the cost, or actually if you're the true owner of the debt. So which is one of the problems and the barriers that the work group realized that's a problem, and we need to figure out and identify how to do it, and we're going to come up with proposed court rules to fix that.
Got it. All right, so what next? What happens in this process that causes other problems?
Well, service is also a problem. We talked about what service is. It's really, that's the opportunity for the defendant to know that there's a case against them and to understand what is being claimed by the creditor. Unfortunately, there are a lot of breakdowns with service. I said that certified mail is allowed, and the defendant is required to sign for that. But Many postal workers don't actually check to see who the person who signed is, and signatures could just be a scribble, and you don't know that whether the person was actually served with that by certified mail. Process servers, there have been instances where process servers have filed fraudulent proofs of service claiming that they served defendants when they actually have not, and maybe have not even attempted service.
And they could be a professional process server, or they could just be somebody else.
Right. It can
Just
be
another
anyone
person.
over the age of 18 who isn't a party to the lawsuit can serve that complaint. So really, the checks on that are not great, and the court doesn't have the resources to look into every single proof of service. They just accept them as true. And it can also be that the creditor does not have an accurate address for the defendant in the case. And so,
Because they brought these debts from long ago, right? So
Yeah,
people could have moved 2 or 3 times before
so they may be
collected.
sending it to an address where the person no longer lives. And that's especially common with debt buyers because they receive essentially a spreadsheet. And they have no idea when the information was from or how accurate it is, or even whether the address is complete. And when they don't, when the plaintiff doesn't have an address and they've attempted service, they can go to court and ask for alternate service. And alternate service is supposed to be designed to give the person notice. But unfortunately, the means that are available to the plaintiffs in a case for alternate service don't usually provide actual notice. So the rules allow plaintiffs to publish in the newspaper a notice in the legal notices section.
That everybody reads.
That
right?
everybody
Everyone
reads,
the
right,
legal
right. When was
notices.
the last time you read a newspaper in and of itself? And certainly, I'm guessing you didn't thumb to the legal notices section. Or it could be posting in the courthouse. That's another method.
So I've seen those big boards, like big bulletin boards, where there's postings up.
I've seen them too. In fact, I took a picture a few years ago of a glass case with notices in it. There were about 100 in a pile tacked to the bulletin board inside a locked glass case. So if by chance the person with the notice on the top came and looked, they would actually potentially have some notice of their case. But the other 99 people whose documents were stacked behind there would have no idea. So really, there are significant problems with alternate service, and unfortunately, many courts are too quick to allow that to occur. And we wanted to make sure we could solve that as well as issues with actual service.
And so does that service problem lead to problems of the debtors really participating in their case,
Yeah,
right?
absolutely. So service, lack of service is one of the reasons that people don't participate. But like I said, most people don't participate in these debt collection cases. 70% essentially nationwide end in default judgment, and that's similar in Michigan. People often get the documents and don't understand what they're receiving, or they don't recognize the name of the plaintiff because maybe, in my case, I had my debt from Beaumont Hospital, but when they sold it to LVNV Funding, I don't know who LVNV Funding is.
So you think this doesn't apply to me, and
right, and
set it
toss
aside.
it. Think that it's not real, or somebody's trying to pull one over on me. Or it could be that I just don't have the bandwidth to deal with this right now. Maybe I've got stuff going on with my kids or my health or my job, and I don't know what to do and can't go to court, don't have time to go to court. And most likely I can't find an attorney. There just aren't enough attorneys out there to handle these cases. I may or may not qualify for legal aid. Legal aid has very strict income guidelines, and just because I can't pay a debt doesn't mean I could qualify necessarily for legal aid. And most legal aid organizations, like your own, have to prioritize other things. People are being evicted from their homes. There are victims of domestic violence who you're trying to keep safe. And debt collection, unfortunately, is one of those case types that doesn't get a lot of attention from legal aid organizations.
Right. It's particularly when they're smaller debts, right?
Yeah,
It doesn't,
yeah.
when you look at the whole cost-benefit analysis, it doesn't mean it's not important for that person who has the
Right,
debt.
right.
But in the greater scheme of things, it's a balancing.
And most of the debts are small. Most are around $3,000 to $4,000 on average. And so that can often be, around the same amount or even less than what it would cost to pay an attorney
Right.
to handle these cases. So there aren't attorneys out there looking to help people with $3,500 debts, and there aren't attorneys who are used to even doing this kind of work because
Right.
nobody's out there. So and sometimes people just decide, you know what, it's not worth me going to court. I know I owe the debt. I don't have a defense, and I can't get out of it.
And I'll
so
just
that
let it go.
happens too. Yeah. But certainly participation is a problem, and that was something we were trying to address as well.
Right. What about the next steps? What when there's a judgment and then there's actually collecting on that?
Yeah, which is the problem when you don't participate, and Matt mentioned the 70% default rate, right? So, because the next step now is that your assets are being seized, right? So, which is the garnishment process. The next step is the plaintiff debt buyer, now the judgment creditor, will be garnishing your wages and your bank accounts, and so that's sort of the first step. And so often, though, the most common form of garnishment is the tax refund, and including also the earned income tax credit, which as legal aid, as you know, that's probably most of the times we actually see those clients, because that's the first time the clients are aware that there was a debt collection lawsuit against them, because they're now not getting their tax refund, or their wages have been garnished, a huge chunk of it has been garnished, and so they're now responding to not having their wages and not having their tax refund. So they're now either ready to participate, and the first time they're aware of it. But the unfortunate thing, though, is that Michigan doesn't have strong consumer protections around the exemptions, right? The exemptions. So if they're garnishment, there's a certain amount of your assets that can be exempt from garnishment. But so right now, Michigan has a large portion of your wage checks that can be garnished. They can also garnish your entire bank account and seize a good portion of your assets. And so that's
Take your entire bank account.
Yes, to zero. Currently on the Michigan law, yes, that's what can happen. And so, in fact, Michigan rates poorly nationally about its protection and exemptions in each state. The National Consumer Law Center did a statewide study of exemption statutes throughout the state, and Michigan failed it. Michigan had an F. Michigan received an F. Michigan needed to increase its exemptions. The last time Michigan amended its statute was in 1964, so it's very antiquated. It still has protections for exemptions for the church pew or farm animals in the statute, so it's still there. So fortunately, Senator Irwin is actually proposing some legislation currently in the Senate to increase those exemptions, to protect those exemptions, to increase the amount of protections you can have from your wages, and to make sure your bank account is not wiped out completely, that there's at least an amount of money in your bank account that will be protected from garnishment. So that's sort of in the process. So hopefully, that will be implemented. But definitely, it's a problem. But what consumers who are faced with garnishment should really realize, because this can happen, is to really two things: reach out to an attorney to see if there's a way to stop the garnishment, and there can be, because something in Michigan, there's a court rule where you could go in and file a motion for installment payment that would stop the garnishment right away, at least for your wages, not for your maybe other checks that are not wages.
But you could pay it over time instead of taking that whole chunk at one time.
Exactly.
Okay.
So to pay it over time. Or also, if you are someone that's receiving federal benefits or any kind of benefits, those are considered exempt automatically. So you need to be aware of the different assets that are exempt, exist currently under Michigan law. Hopefully, with the legislation that will pass, we'll have more protections. But at least the protections we do have is that there are a number of federal benefits that are exempt, and consumers should be aware of that and making sure that those benefits are protected.
Great, great. And I want to talk about who's most impacted by the whole debt collection process.
Yeah. So, unfortunately, low-income consumers, are highly impacted. Even though the debt collection filings are, throughout the entire state, there's a higher percentage of debt collection filings against consumers who are low income. In fact, the report that was studied, the report from the debt collection work group from the research showed that 50% of the filings are against consumers with income of $50,000, medium income of $50,000 or less, whereas the medium and high income individuals are far few debt collection filings. So yes, definitely those are impacted, are the low income consumers there. Also, significantly, when we looked at the reports and the data, that also it showed that racial disparity exists in debt collection, that there's a high percentage of individuals living in community that have a high rate. In fact, it's 2 to 3 times more of debt collection filings or people living in Black community than in the white community. And also more interestingly or significantly, the data that reveals that as the debt collection filings dropped, as the income increased in the white community. However, as to the Black community, the debt collection stays consistently throughout all of the income levels. So it didn't matter that the income was increasing at all. So that was a significant piece of data.
Well, I know you've talked about some of the recommendations, and as we wrap up, I want to make sure we hit on the things we haven't covered yet. Are there other recommendations or things that are in the works that the work group recommended that should happen?
Yeah, I mean, Lorray talked about the complaint and adding additional.
So for the complaint, to increase the evidence, right, that needs to show proof, especially if you're going to do a default judgment, you need to at least have all of the record and data and evidence to support that judgment. So to increase by making sure that you have the proof that this is in fact a contract and a debt that you owed, and so attach those documents, which either be in the written contract or a statement that show that you have used the debt. Clearly improvement of the chain of assignments, that you are the right person to collect on the debt, so you need to attach the assignments, if not all of the assignments, but the list of all of the assignments.
So including all that proof that's necessary to show their case when they show up, at least they had to prove that that's necessary.
And one critical piece too is also identifying the original creditor and the store of which the creditor is from. So as Matt mentioned earlier, as a consumer, if I received a collection notice or a lawsuit from an ABC debt collector, I may think this is a scam because I don't know who ABC debt collector is.
So identify this as a Beaumont
Exactly.
debt. And so,
exactly. And you might get more of a response in consumer participation in the process because they're now responding to, oh yeah, this is my Beaumont debt that I owe. I need to respond to this.
Yeah. And we wanted to improve service as well, and I mentioned that. But requiring process servers to use GPS tracking to show that they were at the location, and photographs. I mean, I sent my mom flowers last weekend, and the delivery guy sent me a photo of the flowers on the porch, and yet we don't require that same thing, even though everybody's got a cell phone with them. So, they should be describing the person that they delivered the package to in order to show that they were actually there. Doing some of those things to make sure that service is actually being accomplished, and doing more to require plaintiffs to try to find real addresses before they can get alternate service. But ultimately, the goal is to get more people to participate when they have defenses, and to make sure that they have the opportunity to go to court, understand what they're doing. So we want to improve court forms, make sure that that it's clear who is suing them and what is being claimed, and then we want people to understand what their rights are, what money they have to pay, what money they don't have to pay, that they don't have to pay out of their benefits or other things.
Right.
And that's part of the reason why we're here today, is to talk about those things and to try to educate people on that. But ultimately, we want to keep people from getting in these terrible situations where they've got wages being garnished and they don't have enough money to live because of some debt that they could not deal with.
Got it. So making sure people understand what it is, that the creditors have to show that they have the debt, and then making sure it is the person who knows and that they participate.
Yes.
Right? And are there resources available for people who are facing lawsuits that you would refer people to if they get these kind of notice in the mail or on their door?
So we regularly refer people to legal aid, but as we said, there aren't enough legal resources out there for folks. MichiganLegalHelp.org is also great and has a lot of excellent resources on there, self-help resources for people.
Yeah. Definitely. I was just going to say a lot of this focus was also on the self-represented, because legal aid, as you know, can't represent everyone.
Right.
So the Michigan Legal Help website has a really good section on debt collection and garnishment and what to do and a series of steps to take. So it's very helpful for the self-represented.
Wonderful. And they can get access to lawyer information there on that same website. So
Yes.
it's a great place for people to start. All right.
Yes.
Well, there's a lot of information, and Matt and Lorray, I'm so glad you were here to help us break it down and understand it a lot better. I hope folks will understand that they do need to go and get help if they get these notices in the mail, and just not ignore it and wrap it up and be able to address it before it gets to be a big problem. So thank you for being here.
Thank you, Ashley.
And thank you for joining us on Legally Speaking. For more information on debt collection in Michigan, visit the Michigan Justice for All Commission website and look for the report, Advancing Justice for All in Debt Collection Lawsuits.